Hello, today we are gonna talk about the 2014 case Riley v. California. David Riley was arrested on August 22nd of 2009 after a traffic stop revealed guns in his car. Riley had his mobile phone in his pocket when he was captured, so the police investigated the videos and pictures in it. Based in part on the data saved on Riley's phone, the officers charged him with an independent shooting that had taken place several weeks before his detention. Riley moved to suppress all the evidence the officers had obtained during the research of his cell phone because the research disrupted his Fourth Amendment rights. The trial court declined this argument and held that the research was rightful incident arrest. Riley was consequently sentenced. On appeal, the court declared the judgment based on the recent California Supreme Court decision People v. Diaz. In Diaz, the court held that the Fourth Amendment search incident to arrest doctrine permits the policeman to carry a full research of a cell phone whenever the phone is found near the subject at the time of arrest. The Riley panel concurred with the trial court that Diaz controlled. The defendant in Diaz requested a review in the U.S. Supreme Court, but while his petition was pending, the California legislature enacted a bill requiring police to acquire a warrant before examining the contents of any portable electronic devices. The court subsequently denied the petition after the state brought this bill to its attention, but 1 week later the governor declared the bill, stating that courts are better suited to decide this issue of Fourth Amendment law. Finally, the Supreme Court held that the police, after arresting someone, generally cannot conduct a warrantless research of the person's cellular phone. This decision is important because, as a generic rule, the police officers are empowered to conduct a warrantless research of those who they arrest. Police officers can research the pocket, bags, purses, and immediate surroundings of detained people without the need of any warrant, just with the purpose of protecting officer safety and preserving evidence, neither of which is at issue in search of digital data. This case involves a significant Fourth Amendment privacy issue that impacts millions of Americans each year. The holding is that the police generally may not, without a warrant, research digital information on a cell phone seized from an individual who has been arrested. The Supreme Court stated unanimously that this type of intrusive research without a warrant was unconstitutional. Chief Justice John G. Roberts, Jr. wrote the opinion for the unanimous court. Mobile phones are not dangerous to police officers, as they are not weapons. Also, without searching the phone, the police can take alternative measures to secure the data on the phone and to prevent the data from being destroyed, such as disconnecting the phone from the system and placing the phone in a Faraday bag. Mobile phones often contain significant amounts of highly sensitive personal information. The Supreme Court characterized them as mini-computers filled with massive amounts of private information, which distinguish them from the traditional items which could be seized from an arrestee's person. Nevertheless, the court held that some warrantless researches of cell phone might be authorized in a crisis, when the government's interests are so compelling that research would be reasonable. The verdict had a large impact, as even now any police officer who wants to research on the cellular phone of any person they arrest will have to get a warrant first. I hope you liked my video and thanks for watching.